Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. This video constitutes an academic review of historical market trends and legal industry evolution. It does not, under any circumstances, constitute legal, financial, or professional advice. The historical data and case studies presented are for contextual understanding of the U.S. legal market and should not be used as a basis for personal legal decisions. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional regarding any specific legal or financial matters. The most lucrative sector of the American legal system was not built on high-stakes corporate mergers, nor was it forged in the fires of patent litigation between tech giants. Instead, it was built on the wreckage of the American household. For over a century, the U.S. divorce attorney market has functioned as a massive counter-cyclical economic engine, shifting from a clandestine, under-the-table necessity to a $50 billion a year professional juggernaut. But why does the cost of a domestic dissolution fluctuate so wildly between jurisdictions? Why did certain states like Nevada and South Dakota once function as divorce mills that literally funded their state treasuries through legal fees and residency requirements? Most importantly, how did a profession that was once considered the basement of the legal world transform into a prestigious, data-driven industry that utilizes advanced psychological profiling and forensic accounting? Today, we are embarking on a deep-dive masterclass into the historical evolution of the divorce attorney market. We are going to peel back the curtain on the Reno divorce era, the impact of the 1969 no-fault revolution, and the economic shift from proving guilt to distributing assets. By the end of this 10-part series, you will understand the structural mechanics of how legal fees are generated, how market saturation has changed the way attorneys find clients, and how the historical precedents set in the 20th century continue to dictate the price you pay for legal representation today. This is not just a look at laws. It is an academic autopsy of a market that thrives on the most volatile asset in existence: human relationships. To understand the modern market, we must first analyze the era of migratory divorce. In the late 19th and early 20th centuries, the divorce attorney market was heavily restricted by fault-based statutes. In many states like New York, the only legal ground for divorce was adultery. This created a massive supply and demand imbalance. Thousands of Americans wanted out of their marriages, but the legal cost in their home states, both in terms of reputation and the evidentiary burden, was too high. This led to the birth of the divorce colony. Historically, lawyers in states with shorter residency requirements and broader legal grounds realized they could export their legal services. Sioux Falls, South Dakota, became the first major hub. In the 1890s, an attorney in Sioux Falls could charge a premium not just for their legal knowledge, but for their ability to navigate a system that required only 90 days of residency. This was the first time we saw the commodification of jurisdictional arbitrage. Attorneys weren't just selling legal advice, they were selling a legal destination. During this period, the market was characterized by a high volume of wealthy out-of-state clients who would move to these colonies, stay in local hotels, and pay substantial retainers to local firms. This created a secondary economic boom for these cities, where the legal market and the hospitality market became inextricably linked. However, the real shift in the market's valuation occurred in the mid-20th century, with the rise of the Silver State model. Nevada, and specifically Reno, realized that the divorce market could be optimized for maximum revenue. In 1931, Nevada lowered its residency requirement to just 6 weeks. This was a calculated economic move to attract litigation tourists. If you look at the historical data from this era, the number of divorce attorneys in Reno per capita was significantly higher than in any other U.S. city. These lawyers were pioneers in what we now call niche marketing. They focused entirely on the quickie divorce, streamlining the process into a high-volume, high-margin business. The financial structure of these firms was fascinating, because the clients were often from the upper echelons of society, celebrities, socialites, and business tycoons. The attorneys could charge what were then astronomical fees. A standard Reno divorce in the 1940s might cost $2,500 in legal fees alone, which, when adjusted for inflation to $2,026, represents a significant investment. This era proved that the divorce market was not just about poor people with problems. It was a high-end service industry for the wealthy. Everything changed in 1969 when California Governor Ronald Reagan signed the Family Law Act. This introduced no-fault divorce to the United States, and it fundamentally rewired the economics of the legal profession. Before 1969, a divorce attorney's primary job was detective work. They had to hire private investigators and gather evidence of cruelty, desertion, or adultery to win a case. The legal fees were often tied to the difficulty of proving fault. When irreconcilable differences became the standard, the market moved from an evidence-based model to an asset-based model. Attorneys no longer needed to spend hundreds of billable hours proving someone was a bad spouse. Instead, the focus shifted to the division of property, pensions, and business interests. This is where the modern divorce attorney market truly began to take shape. The billable hour shifted from the courtroom to the counting room. We saw the emergence of matrimonial law as a distinct, specialized field within the American Bar Association. Consider the case studies of the 1970s and 80s. As women entered the workforce in record numbers and dual-income households became the norm, the complexity of marital estates exploded. A divorce attorney in 1985 had to understand 401k valuations, stock options, and the appreciation of real estate. This increased the barrier to entry for attorneys. You could no longer be a general practitioner who did a little divorce on the side. To be competitive in the market, you had to become a specialist in forensic accounting and tax law. This specialization drove up the cost. Between 1980 and 2000, the average cost of a contested divorce in the United States grew at a rate that outpaced general inflation. Why? Because the product being sold by the attorney changed. It was no longer just a decree of dissolution. It was a comprehensive financial restructuring plan. The market began to segment into high net worth, H&W, practices and standard practices. H&W attorneys started charging retainers that could range from $25,000 to $100,000 just to begin the discovery process. Another critical historical trend we must examine is the impact of Bates v. State Bar of Arizona in 1977. This Supreme Court case allowed lawyers to advertise their services for the first time. Before this, the divorce attorney market relied almost entirely on word of mouth and professional reputation. After 1977, the market was flooded with information. We saw the rise of the lawyer billboard and the television commercial. This created a race to the bottom for simple uncontested divorces, where firms began offering flat fee services for as little as $200. Conversely, it allowed top-tier firms to brand themselves as aggressive or elite, further bifurcating the market. In this first part of our deep dive, we have established that the U.S. divorce attorney market is not a static entity. It is a dynamic ecosystem that responds to legislative changes, economic shifts, and social norms. We have seen how it moved from the divorce colonies of South Dakota to the high-stakes financial litigation of the modern era. In the next part of this masterclass, we will break down the specific billable hour mechanics and how forensic technology has changed the way attorneys hunt for hidden assets in 21st century litigation. We are moving from the history of the where to the science of the how. The science of how the U.S. divorce attorney market generates revenue is rooted in a single uncompromising unit of measurement, the 6-minute increment. To understand the modern deep dive into legal fees, we have to look at the mechanics of the billable hour, which functions as the atomic structure of the industry. In the historical transition from the 1970s to 2026, the methodology of billing shifted from a general estimation of labor to a high-precision, data-backed extraction of value. When an attorney opens a file, they are not just looking at a legal problem. They are looking at a chronological puzzle where every phone call, every email, and every minute spent thinking about the case is quantified as 0.1 of an hour. Imagine if you are John, a small business owner in Ohio in 1985. When John went to see a divorce attorney, the process of discovery was a manual, grueling, labor-intensive task. The attorney's team had to physically subpoena boxes of paper records from banks, title companies, and employers. The billable hours in 1985 were largely dominated by the physical sorting of these documents. An associate attorney might spend 40 hours in a basement room, literally looking for a discrepancy in a ledger. The cost to John was high because of the sheer volume of human hours required to perform basic tasks. Historically, this meant that the market was limited by the speed of human eyes on paper. Now, let us contrast that with the 2026 market environment. Imagine if you are Sarah, a high-earning software executive in Austin, Texas. In 2026, the divorce attorney market has integrated advanced forensic technology that has fundamentally changed the cost-benefit analysis of litigation. Today, the discovery process is no longer about physical boxes. It is about digital footprints. Attorneys now utilize AI-driven software that can ingest 10,000 pages of bank statements, credit card transactions, and Venmo histories in seconds. This software uses pattern recognition to flag unusual spending or lifestyle markers that do not align with reported income. However, do not assume that this technological efficiency has lowered the cost for the consumer. Historical trends show the opposite. As the technology became more efficient at finding information, the legal market responded by increasing the depth of the investigation. In 2026, because the attorney can find the data faster, they spend more time analyzing the nuances of that data. The billable hour has not been replaced. It has been redirected toward high-level strategic interpretation. A modern forensic legal team might charge for the use of the AI software as a line-item expense, while still charging the partner's hourly rate to review the red flags the software generated. This brings us to the science of hunting for hidden assets, which is a major driver of the $50 billion legal market. Historically, hiding assets was a matter of offshore bank accounts in the Cayman Islands or literal cash under a mattress. In the mid-20th century, an attorney's hunt involved looking for ghost employees on a spouse's business payroll or deferred bonuses that were intentionally delayed until after the divorce decree. In the 2026 landscape, the hunt has moved into the realm of decentralized finance and digital assets. A sophisticated divorce attorney now employs digital forensic experts who specialize in blockchain analysis. Case studies from the early 2020s showed a massive spike in crypto divorces, where one spouse would attempt to shield wealth in hardware wallets or through privacy coins. The legal market adapted by creating a new subspecialty, the crypto forensic attorney. These professionals use chain-hopping tracking tools to follow the movement of wealth through various protocols. The cost for this expertise is immense. In a 2026 high-net-worth case, it is common to see an initial retainer specifically for digital discovery ranging from $30,000 to $50,000. The economic engine of this market is fueled by the discovery phase, which is often the most expensive part of any U.S. divorce. To understand why, we must look at the interrogatory process. This is a series of written questions that one side sends to the other. In a typical 2026 case, these are not just simple questions. They are strategically crafted legal traps designed to elicit contradictions. If Sarah's attorney sends a set of 50 interrogatories to her spouse, the spouse's attorney must spend hours drafting responses. Each draft is billed. Each revision is billed. Each consultation about the response is billed. This creates a multiplier effect, where 1 hour of work by one side can force 3 hours of work on the other. Data shows that the more conflict there is in a case, the higher the revenue for the legal market. This has led to an academic debate regarding incentivized conflict. While most attorneys aim for a swift resolution, the structural reality of the billable hour model means that a peaceful, mediated settlement generates significantly less revenue than a multi-year litigation battle. This is why we see the emergence of aggressive representation as a marketing pillar. By framing the attorney as a warrior or a shark, the market appeals to the emotional state of the client, which historically leads to a higher tolerance for high legal fees. Let's look at the expert witness market as a secondary layer of this industry. In 2026, a complex divorce doesn't just involve two lawyers. It involves a legal ecosystem. This includes vocational experts who testify on a spouse's earning capacity, child psychologists who testify on custody arrangements, and business valuators who determine the goodwill value of a company. Each of these experts charges their own hourly rate, often matching or exceeding the attorney's rate. The attorney acts as the general contractor of this team, and they typically charge a fee to coordinate and review the work of these experts. In a historical context, the professionalization of these secondary roles has transformed divorce from a legal procedure into a multidisciplinary corporate project. Step by step, the financial escalation of a case often follows a predictable trajectory. First, the retainer phase, where capital is secured to cover initial costs. Second, the temporary orders phase, which sets the baseline for support in custody while the case is pending. This is where the market captures the most immediate emotional spend. Third, the discovery phase, where the bulk of the forensic accounting occurs. Finally, the pre-trial phase, where the threat of a full trial is used to force a settlement. Historical data indicates that over 90% of U.S. divorces settle before a final trial, yet the trial preparation fees are often some of the highest on the final invoice. This is because the potential outcome of a trial is so risky that clients are willing to pay a premium to be ready for a day in court that likely will never happen. As we look at the sheer scale of this market, we must ask, what happens when the legal fees begin to consume the very assets the parties are fighting over? This is the scorched earth phenomenon, a critical market trend where the cost of the hunt exceeds the value of the prey. How do attorneys navigate the ethics of billing when the marital estate is being liquidated just to pay the firms? In the next part of this deep dive masterclass, we are going to explore the psychology of the bill. We will examine the specific tactics used to maintain client loyalty during periods of financial exhaustion, and how the burn the house down strategy became a recognized, albeit controversial, maneuver in high-conflict litigation. We will also look at the rise of legal funding companies, the third-party investors who are now literally betting on the outcome of divorces by financing the legal fees in exchange for a cut of the final settlement. The market is no longer just between two people. It has become an institutionalized asset class. The institutionalization of the U.S. divorce attorney market has led to the emergence of a sophisticated psychological framework known among practitioners as the management of litigation fatigue. To understand the psychology of the bill, we must analyze the sunk cost fallacy as it applies to family law. By the time a high-conflict case reaches the 12-month mark, the client has often invested more in legal fees than the initial delta of the dispute. In 2026, the average contested divorce in a major metropolitan area like New York or Los Angeles can easily see legal fees crossing the $200,000 threshold. When a client reaches this point, the attorney's role shifts from legal advocate to a financial and emotional strategist. The attorney must justify the next $20,000 retainer by framing it as a protective measure for the previous $200,000 already spent. Historically, this is where we see the highest rates of client turnover, as the financial exhaustion begins to outweigh the desire for a specific legal outcome. Imagine if you are Michael, a mid-level executive in Chicago in 2026. You are 18 months into a divorce. You have already spent $80,000 on your legal team. Your attorney tells you that to secure the specific parenting time schedule you want, you need to hire a rebuttal vocational expert because your spouse is claiming they cannot work. This expert will cost another $15,000. This is the moment of tactical exhaustion. In the 2026 market, attorneys use data-driven historical trends to show Michael that if he stops now, his previous $80,000 investment may yield a suboptimal result. The market thrives on this all-in mentality. It is a psychological trap where the cost of retreat is perceived as higher than the cost of continued engagement. This leads us directly into the controversial market strategy, known as the burn the house down maneuver. Historically, this tactic was reserved for the most vitriolic cases, but in the modern era, it has become a documented economic strategy. The goal of this maneuver is not necessarily to win a specific asset, but to utilize the legal system to cause maximum financial depletion of the opposing party. In this scenario, one party, often the one with higher liquidity, initiates a barrage of motions, depositions, and discovery requests. Each of these actions requires the other party to respond, effectively forcing them to spend their own legal capital. Case studies from the early 2020s show that this strategy is often used as a tool of attrition-based settlement. If Party A can force Party B to spend $50,000 in legal fees in a single month, Party B may be forced to settle for a lower percentage of the marital estate, simply because they can no longer afford to keep their attorney on retainer. This is a brutal economic reality of the market. The attorney's role in this maneuver is to provide the ammunition. While the attorney cannot ethically pursue frivolous litigation, the complexity of modern financial lives provides nearly infinite good faith reasons to request more information, prolonging the billable cycle and draining the adversary's resources. However, a major market disruption has occurred in recent years to counter this imbalance: the rise of the divorce litigation funding industry. This is where the divorce market truly becomes an institutionalized asset class. Imagine if you are Jennifer, a spouse in 2026 who has been out of the workforce for a decade. Your spouse, Michael, is using the burn the house down strategy, and you have zero access to the marital bank accounts. Historically, you would have been forced into a predatory settlement. Today, however, you can turn to a third-party legal funding firm. These firms treat Jennifer's divorce like a high-growth startup. They do not look at her credit score or her current income. They look at the marital estate delta. They employ their own team of analysts and former judges to review the case files. They ask, what is the total value of the assets? What is the likelihood of a 50-50th split? How long will the litigation take? If the numbers work, the funding firm provides Jennifer with a non-recourse line of credit to pay her attorneys. Step by step, the mechanics of these 2026 funding contracts are intensive. The funder might provide $500,000 in legal fees. In exchange, they don't just want their money back with interest. They often take a success fee or a percentage of the final settlement. Historical trends in this sector show interest rates that can range from 15 to 30%, compounded. While this provides the under-resourced spouse with the firepower to stay in the fight, it also introduces a third party into the negotiation who has a vested financial interest in the case not settling too early for too little. The funding company becomes a shadow partner in the divorce, influencing strategy by deciding which legal expenses they will or will not approve. This institutionalization has created a secondary market for risk assessment in matrimonial law. In 2026, we see the emergence of divorce hedge funds that bundle hundreds of these funded cases into a single portfolio. By diversifying across different jurisdictions and different types of marital estates, these funds aim to produce consistent returns for their investors, regardless of individual case outcomes. This has fundamentally shifted the leverage in the attorney market. A lawyer representing a funded client knows their bills will be paid on time by a corporation, rather than waiting for a client to liquidate a house. This makes funded clients highly desirable, creating a new tier of elite funded practices. But what happens to the psychology of the attorneys themselves in this high-stakes environment? We must examine the professional conflict of interest inherent in a market that bills by the hour but settles by the compromise. In an academic review of the historical data, we see that the most successful firms in terms of gross revenue are those that master the art of the pivot. This is the ability to keep a case in high-conflict litigation for the first 12 months, generating massive discovery and motion fees, and then pivoting toward a mediation or settlement just before the trial date. This pivot is a masterclass in client management. The attorney transitions from being the warrior to being the voice of reason, explaining to the client that the potential outcome of a trial is too risky. This allows the firm to capture the maximum amount of conflict revenue, while avoiding the high-risk, low-margin labor of a multi-week trial. For the client, this can feel like a sudden reversal of strategy, but from a market perspective, it is the most efficient way to close a file and move on to the next retainer. As the market continues to evolve in 2026, we are also seeing the commoditization of the second chair. Large firms are increasingly outsourcing the grunt work of document review and basic motion drafting to lower-cost jurisdictions or sophisticated AI systems, while still billing the client at the firm's standard associate rates. This arbitrage of labor has significantly increased the profit margins for the partners at the top of the pyramid. The gap between the cost of production for a legal document and the price to the consumer has never been wider. In this deep dive, we have moved from the individual psychology of the sunk cost to the institutional reality of hedge fund-backed litigation. We have seen how the burn-the-house-down strategy created a vacuum that third-party funders stepped in to fill. The U.S. divorce attorney market is no longer a localized service industry. It is a globalized financial ecosystem where the breakdown of a marriage is a yield-generating event for institutional investors. In the next part of this masterclass, we will look at the shadow judiciary. We will explore how the wealthiest 1% of the market has abandoned the public court system entirely in favor of private judges. We will break down how these rent-a-judges operate, the secret protocols they follow, and why the most expensive divorces in America are now happening in conference rooms instead of courthouses. We will also examine the non-disclosure economy, where the legal market is paid a premium to ensure that the details of a wealth transfer never become a matter of public record. The public courts are for the masses. Private courts are where the real market power resides. The transition into the shadow judiciary marks the ultimate divergence in the U.S. divorce attorney market. While the average American litigant battles through a backlogged public system where a single motion hearing might be scheduled 6 months out, the top 1% of the market has opted out entirely. This is not a conspiracy. It is a statutory reality. In states like California, under Code of Civil Procedure Section 638, parties can mutually agree to appoint a referee, more commonly known as a private judge, to hear and determine any or all of the issues in their case. This creates a parallel legal universe where the primary commodity being sold by attorneys is no longer just legal expertise, but total systemic avoidance. To understand the economics of this, imagine if you are David and Elena, a power couple in the 2026 tech sector. They are dissolving a marriage involving a $3 billion valuation of an AI-driven logistics firm. If David and Elena proceed in the public court system, every financial statement, every valuation report, and every embarrassing text message entered into evidence becomes a public record. In 2026, where AI-powered legal scrapers index every new filing within seconds, this level of transparency is a catastrophic business risk. A single leaked deposition could trigger a sell-off of company stock or a loss of investor confidence. This is where the elite divorce attorney markets the private judge as a high-premium insurance policy. The attorney's role shifts from a litigator to a logistics manager. They select a retired appellate justice from a boutique firm, someone whose hourly rate often mirrors or exceeds their own. Historically, we have seen these private judges charging anywhere from $800 to $1,500 per hour. This fee is paid by the parties, split down the middle or allocated by the judge. When you add this to the fees of two sets of high-powered attorneys, the burn rate of a private divorce can exceed $10,000 per day of hearing. But what does this buy? It buys the non-disclosure economy. In a private hearing held in a high-security conference room in Century City or Manhattan, the public is not invited. There are no reporters. There are no spectators. The record of the proceedings is kept by a private court reporter, and the documents are often filed under strict sealing orders that are rarely challenged because no one outside the room even knows they exist. The historical trend shows that as public interest in high-profile splits increased with social media, the demand for these private forums exploded. Between 2015 and 2026, the volume of private domestic relations judging grew by an estimated 40% in major legal hubs. The attorney market for these cases is incredibly insular. There are perhaps only a few hundred lawyers in the entire United States who regularly operate in this shadow tier. These attorneys do not use traditional marketing. They operate through a referral network of wealth managers, family offices, and corporate counsel. In this market, the attorney is valued for their discretion as much as their courtroom prowess. The case studies of 2026 show that these super practices often function more like multifamily offices than traditional law firms. They have in-house security consultants to prevent eavesdropping during meetings and cyberforensic teams to ensure that the private judge's digital portal is encrypted against leaks. However, the academic review of this trend reveals a significant societal cost: the erosion of public precedent. Historically, family law evolved through public appeals and published opinions that provided guidance to all citizens. When the most complex, high-value, and legally innovative cases are settled in private rooms, the common law stagnates. The private judge's decision, while binding on the parties, does not become a law that a middle-class family in a public court can cite. This creates a two-tiered system of justice where the rules of the road for the wealthy are developed in secret, while the rest of the country operates under outdated or oversimplified statutes. Step by step, the process of entering the shadow judiciary is a high-stakes legal maneuver. First, the attorneys must draft a stipulation for appointment of privately compensated judge. This document must be signed by both parties, and then approved by the presiding judge of the public court. Once the public judge signs off, the case is effectively exported. The private judge then takes an oath of office, and from that moment on, they have the full power of a state court judge. They can issue contempt citations, sign warrants, and make final rulings on the distribution of assets. The financial infrastructure of these private courts is a masterclass in market optimization. These retired judges are often managed by agencies, such as JAMS or AAA, which function as the talent agents of the legal world. These agencies take a percentage of the judge's hourly fee in exchange for providing the administrative backend, the conference rooms, the scheduling clerks, and the secure document servers. For a divorce attorney in 2026, the ability to pick your judge is the ultimate tactical advantage. They look for a judge who has a historical trend of favoring certain types of asset valuations, or who has a reputation for being reasonable regarding spousal support durations. This leads to the concept of forum shopping 2.0. In the public system, you are assigned a judge by the luck of the draw. In the private market, you and your opposing counsel negotiate until you find a judge you both trust, which often means a judge whose previous rulings suggest a predictable outcome. This predictability is worth millions. If an attorney can tell their client, Elena, that a specific private judge is 80% likely to characterize her premarital intellectual property as separate property, Elena will gladly pay the $500,000 premium for that judge's time. The case of a 2026 founder's divorce illustrates this perfectly. Imagine if Elena's AI firm is valued at $1 billion, but that value is largely based on a proprietary algorithm she developed 2 years before the marriage. In a public court, a judge who spent the morning hearing 10 cases about overdue child support might not have the cognitive bandwidth or the specialized training to understand the nuances of software patent valuation. The risk of a bad ruling is too high. By paying for a private judge who was formerly a specialist in intellectual property law, the attorneys are buying judicial competence. As we analyze this top-tier market, we see that it is completely decoupled from the economic pressures of the rest of the legal industry. While mid-market firms are currently struggling with the AI disruption of their billable hours, these elite firms are thriving. Their product isn't paperwork, it is outcome management. They are selling a result that is shielded from the public eye, delivered by a hand-picked adjudicator, in an environment of total control. But this shadow system is starting to feel the pressure of a new kind of scrutiny. In the 2026 legislative sessions, several states have begun debating transparency acts, aimed at forcing private judges to report their case outcomes and fees to the public record. The divorce attorney market is currently in a state of high-intensity lobbying to prevent this, arguing that privacy is a fundamental right of the individual, regardless of their net worth. We have now explored how the market evolved from divorce mills to hedge fund litigation, and finally into the shadow judiciary. The infrastructure of American divorce is built to accommodate every level of the economic ladder, provided you have the capital to climb it. But as the top of the market becomes increasingly invisible, the middle and bottom are facing a different kind of revolution, one driven by algorithms and mass-market automation. In the next part of this deep dive masterclass, we are going to look at the digital disruption of the mid-market. We will examine the rise of the app-based attorney and how Silicon Valley is attempting to commoditize the legal process for the other 99%. We will break down the flat fee algorithm and how it is forcing traditional family law firms to either scale or fail. The era of the boutique local lawyer is ending. The era of the legal tech giant has begun. The digital disruption of the mid-market represents the most significant shift in legal accessibility in the last century. For decades, the American divorce market was gated by a high financial barrier to entry, leaving a massive segment of the population, the middle class, in a state of legal limbo. Historically, if your marital estate was worth between $50,000 and $500,000, you were in the danger zone. You had too many assets to qualify for legal aid, but not enough liquidity to sustain a multi-year litigation battle with the traditional boutique firm. This gap created the perfect conditions for the rise of the legal tech giant. To understand this transformation, we must analyze the case of Mark, a mid-level manager in suburban Denver in the year 2026. Historically, if Mark had sought a divorce in 1996, he would have opened a physical phone book, called 3 different local attorneys, and paid a $3,000 retainer just to get started. He would have been billed for every photocopied page and every 30-second status update. By contrast, in 2026, Mark utilizes a platform that functions more like a high-end financial software than a law firm. This platform uses a conflict score algorithm to determine his pricing. The conflict score is the backbone of the 2026 mid-market. When Mark signs up, he and his spouse, Lisa, both complete a comprehensive digital intake. This isn't just a basic form. It is a sophisticated behavioral assessment. The algorithm analyzes their level of agreement on key issues: the house, the retirement accounts, and the custody of their children. If the algorithm detects high alignment, it assigns a low conflict score and offers a flat fee package of $3,000 for the entire process, start to finish. If the algorithm detects volatile language or significant disagreement on asset valuation, the price scales dynamically. This is the flat fee algorithm in action. It removes the uncertainty of the billable hour by using historical trends from millions of previous cases to predict exactly how much labor the platform will need to expend. Step by step, the platform handles the document assembly phase. Historically, an associate attorney would spend 6 to 10 hours drafting a petition for dissolution, a summons, and a financial affidavit. In 2026, the platform's logic engine generates these documents in real time as Mark and Lisa input their data. The engine is programmed with the specific local rules for their specific county court. It knows exactly which fonts to use, which margins are required, and which specific statutory language must be included to avoid a rejection from the clerk. This reduces the cost of production for these documents from $2,000 in billable time to nearly zero for the platform. This leads to the scale or fail ultimatum for traditional family law firms. Historically, a small firm with 2 partners and 3 paralegals had massive overhead. They had to pay for office space, specialized legal research databases like Westlaw or LexisNexis, and malpractice insurance. In 2026, these boutique firms are being systematically squeezed out of the mid-market. They cannot compete with the customer acquisition cost of a Silicon Valley-backed legal tech giant that spends millions on targeted search engine dominance. Data shows that in 2026, the average local firm must charge at least $250 per hour just to break even on overhead. The tech giants, however, operate on a high-volume, low-margin model. By automating 90% of the paperwork, they can profitably handle 10,000 divorces a month at a price point that would bankrupt a traditional firm. This has forced local attorneys to make a choice. Either pivot to the high-net-worth elite market discussed in the previous part of this masterclass, or become a contract service provider for the platforms. This is the rise of the app-based attorney. In 2026, many family lawyers no longer own their own practices. Instead, they act as legal consultants for platforms. Imagine if Mark hits a snag in his automated divorce. He and Lisa cannot agree on the valuation of Mark's pension. For an additional fee of $400, Mark can unlock a 30-minute video consultation with a licensed attorney. This is the unbundled legal services model. The attorney doesn't represent Mark for the whole case. They are hired for a specific task, of a micro-engagement. The efficiency of this model is undeniable, but the academic review of this shift reveals a complex historical trend regarding the quality of advocacy. Historically, a lawyer was a counselor, someone who understood the nuances of a family's history. In the automated 2026 model, the counselor aspect is stripped away in favor of computational accuracy. The system is designed to reach a mathematically fair outcome based on state guidelines, but it often lacks the flexibility to handle edge cases that don't fit into the algorithm's parameters. Furthermore, we must examine the API integration between legal platforms and the state court systems. By 2026, many U.S. jurisdictions have fully digitized their dockets. These legal tech companies have built direct bridges into the court's software. When Mark clicks Submit on his dashboard, the documents are electronically filed, the filing fees are paid via a digital wallet, and a hearing date is automatically requested, all without a human being ever touching a piece of paper. This has accelerated the velocity of divorce. Historically, a mid-market divorce took 9 to 12 months to finalize. In 2026, through these automated pipelines, an uncontested divorce can be completed in as little as 30 to 60 days, depending on the state's mandatory waiting periods. The market impact of this velocity cannot be overstated. By increasing the turnover of cases, the legal tech giants have effectively expanded the market. People who previously stayed in unhappy marriages because they couldn't afford the $10,000 retainer are now entering the market at the $3,000 flat fee level. This is the democratization of dissolution, but it comes with a trade-off. The personal touch of the law has been replaced by the user experience of an app. As we look deeper into this 2026 landscape, we see that the subscription model is also beginning to emerge. Some firms are now offering pre-legal protection plans, where individuals pay a monthly fee to have a divorce-ready status, essentially keeping their financial documents perpetually organized and audited by an AI so that if they ever choose to file, the process is instantaneous. This is the ultimate commoditization of a life event. But what happens when the algorithm makes a mistake? What happens when the AI-driven document assembly fails to account for a specific, newly legislated tax loophole? The liability shift in the 2026 market is still being litigated. Are these platforms law firms or software companies? This distinction determines their level of responsibility to the consumer. We have established how the elite escape to the shadow judiciary and how the middle class is being funneled into automated platforms. But there is a third, darker segment of the market that we have yet to touch. It is the segment where the state itself becomes an active financial participant in the outcome of the divorce. In the next part of this 10-part deep dive masterclass, we are going to explore the algorithmic child support and alimony models. We will break down the Title IV funding system and how the U.S. government actually provides financial incentives to states based on the amount of child support they collect. We will analyze how the legal market has adapted to these federal incentives and the hidden collection industry that turns family law into a revenue stream for the state treasury. The divorce attorney is no longer just fighting for their client. They are navigating a system where the government has its own case study on how to maximize collection. We are moving from the app to the agency. To understand the transition from the app-based consumer market to the high-stakes world of the agency, we have to look at the silent third party in nearly every American divorce: the federal government. Most citizens assume that child support and alimony are private matters settled between two parties and a judge. However, an academic review of the historical trends reveals that the state is often a direct financial beneficiary of the orders it issues. This is due to a piece of legislation that serves as the bedrock of the family law economy: Title 4D of the Social Security Act. Since its inception in 1975, and its subsequent expansions, Title 4D has turned the enforcement of child support into a massive revenue-generating machine for state treasuries. Imagine if you are Robert, a freelance cloud infrastructure engineer living in North Carolina in 2026. Robert is going through a divorce, and his primary concern is the monthly child support obligation. In the 2026 market, the calculation of this number is not left to the whims of a judge. Instead, it is governed by a rigid statewide algorithmic model known as the income shares model. This model operates on the philosophical assumption that a child should receive the same proportion of parental income that they would have received if the parents lived together. Step by step, the attorney market has evolved to master this specific math. The process begins with the gross income audit. In 2026, Robert's attorney doesn't just look at his paychecks. They analyze his total economic output. This includes realized capital gains from high-frequency trading accounts, the fair market value of employer-provided benefits like a home office stipend, and even imputed income from non-performing assets. If Robert decided to take a lower-paying job during the divorce to minimize his support, the court uses an earnings capacity algorithm to impute the income he should be making based on his 2026 skill set. This is where the agency enters the room. Under Title 4D, the federal government provides states with massive financial incentives to collect child support. Specifically, the federal government reimburses states for 66% of the administrative costs of their child support enforcement programs. But the real market driver is the performance-based incentive payment. The federal government pays states additional millions of dollars based on 5 specific metrics: the paternity establishment percentage, the percentage of cases with support orders, the amount of current support collected, the amount of arrears collected, and the overall cost-effectiveness of the program. Historically, this created a system where the state is not a neutral arbiter. The state has a direct financial interest in ensuring that support orders are high and that they are collected aggressively. For the divorce attorney market, this means that representing a payer like Robert is no longer about arguing for fairness. It is about navigating a system designed for maximum collection. Attorneys now specialize in finding deviations, specific legal loopholes that allow a judge to go outside the algorithm. For example, if Robert can prove that his child has extraordinary expenses for a specialized tech schooling program in 2026, he might be able to shift the numbers. Now, consider the alimony market in 2026. The historical trend here was shattered by the 2017 Tax Cuts and Jobs Act, which eliminated the tax deductibility of alimony payments for the payer and made them tax-free for the recipient for all divorces finalized after 2018. Before this change, the legal market utilized alimony as a tax-shifting tool, effectively using the IRS to subsidize the cost of a divorce. In the 2026 landscape, the market has pivoted toward lump-sum alimony buyouts. Instead of monthly payments that are no longer tax-deductible, attorneys are increasingly negotiating for a larger share of the marital estate to be transferred up front. This has created a boom for valuation experts. If Robert's spouse is entitled to 10 years of support, how do you value that today? You have to account for the 2026 discount rate, inflation projections, and the potential for a remarriage termination clause. The legal fees generated by arguing over the present value of future support have replaced the fees previously generated by tax planning strategies. This brings us to the contempt of court market, which is the high-margin secondary market of the agency era. When a payer fails to meet the algorithmic obligation, the state-backed enforcement agency can move to suspend Robert's driver's license, seize his tax refunds, or even place a lien on his digital asset wallets. However, these state agencies are often overwhelmed. This has led to the rise of private enforcement attorneys. If Robert's ex-spouse wants the money faster than the state agency can move, They hire a private firm that specializes in post-judgment litigation. These firms don't charge a traditional retainer. They often operate on a contingency-style fee or a flat fee for each motion for contempt filed. In 2026, these firms use automated asset scrapers to monitor Robert's financial life. If Robert buys a new vehicle or posts about a luxury vacation on a decentralized social network, the scraper flags it, and a motion for contempt is automatically generated, alleging that if he has money for luxuries, he has money for the arrears. This is the profitization of enforcement. We are seeing case studies where private equity firms are actually acquiring small family law practices that focus exclusively on these post-judgment collections because the success rate is so predictable. Once a support order is in the system, it is one of the most enforceable debts in the United States, outranking even student loans in its ability to bypass bankruptcy protections. The historical shift here is profound. We have moved from a system of discretionary alimony, where a judge looked at what was just and right, to a system of formulaic extraction. The attorney's value in 2026 is their ability to manipulate the inputs of the formula. If they can categorize a bonus as non-recurring or a business expense as mandatory, they can save or secure their client hundreds of thousands of dollars over the life of the order. But as the state becomes more efficient at tracking every dollar, a new market has emerged for the truly desperate: the jurisdictional flight market. This is the subsector of the legal industry that advises clients on how to move assets, and themselves, out of the reach of the Title 4D machine. As we look at the interaction between the individual, the attorney, and the state agency, we see a feedback loop of increasing complexity. The state creates a rule to maximize collection. The attorneys find a way to circumvent the rule. The state updates the algorithm, and the cycle continues. This has led to a market where family law is increasingly indistinguishable from tax litigation. In the next part of this 10-part deep dive masterclass, we are going to look at the gray market of international divorce. We will examine the Hague Convention and the high-stakes legal battles over international parental abduction. We will break down how the wealthiest clients use sovereign jurisdictions to play one country's laws against another, and the specialized attorneys who act as legal extradition experts in the world of global domestic relations. We are moving from the state agency to the international treaty. The borders are closing, but for the right price, they can be bypassed. The international gray market of the U.S. divorce attorney industry is where the standard rules of domestic law dissolve into the complex, often contradictory web of global treaties and sovereign defiance. In the year 2026, the concept of a marriage being confined to a single zip code is an academic relic. As the professional world has shifted toward hypermobility and digital nomadism, the legal market for international dissolution has expanded into a high-stakes arena where the primary objective is jurisdictional capture. This is the art of securing a home court advantage in a country whose laws are most favorable to your client's specific financial or custodial goals. To understand the mechanics of this global tier, we must first analyze the Hague Convention on the civil aspects of international child abduction. Historically, this 1980 treaty was designed to provide a simplified, summary process for the return of children who were wrongfully removed from their country of habitual residence. However, in the 2026 market, the Hague Convention is frequently utilized as a strategic weapon in high-conflict litigation. Attorneys who specialize in this field, often referred to as treaty navigators, do not argue about who is the better parent. Instead, they engage in a clinical, data-driven debate over the definition of habitual residence. Imagine if you are Alexander, a high-frequency trader who has spent the last 3 years moving between luxury rentals in New York, London, and Dubai. Alexander's spouse, frustrated with the nomadic lifestyle, takes their 2 children to Florida and files for divorce. In this scenario, Alexander's attorney in 2026 does not immediately respond to the Florida petition. Doing so might grant the Florida court personal jurisdiction over Alexander, potentially exposing his global assets to U.S. equitable distribution laws. Instead, the attorney initiates a Hague petition in federal court, arguing that the children's habitual residence was actually London. The goal here is not necessarily to live in London, but to force the litigation into the English court system, which historically views certain types of premarital wealth and trust structures differently than the American system. The legal fees for a single Hague proceeding in 2026 can range from $50,000 to $150,000, and that is before the actual divorce even begins. This is a preliminary strike market where the winner of the jurisdictional battle often dictates the final settlement terms of the entire estate. This leads us to the grave risk of harm exception, which is the most litigated and expensive loophole in the Hague Convention. Historically, a court must return a child unless there is a grave risk that the return would expose the child to physical or psychological harm. In 2026, the definition of harm has expanded to include cyber safety and educational stability. Case studies from this year show attorneys hiring international security auditors to testify that a specific country's digital infrastructure is too unstable to support a child's mandatory AI-integrated schooling. These experts charge $3,000 a day to provide geopolitical risk assessments that serve as the evidentiary basis for refusing a return order. Beyond the Hague Convention lies the truly unregulated frontier, the non-signatory jurisdictions. These are countries that have not signed the international treaties, or that maintain Sharia-based legal frameworks that do not recognize U.S. court orders. The attorneys operating in this shadow international market act as legal extradition experts. They advise ultra-high net worth individuals on how to domesticate their wealth in jurisdictions that offer sovereign immunity against foreign divorce judgments. For example, imagine if Sophia, a billionaire software founder in 2026, moves her primary residence to a jurisdiction like Singapore or a specific free trade zone in the Middle East that has not entered into a reciprocal enforcement treaty with the United States. If her spouse obtains a $500 million judgment in a California court, that judgment might be worth no more than the paper it is printed on once it hits the border of Sophia's new home. The U.S. divorce attorney market has adapted to this by creating global asset tracing teams. These teams utilize private intelligence firms to find jurisdictional pressure points, such as a secondary property in France or a yacht in international waters, where a U.S. judgment can actually be enforced through international comity. The historical trend in 2026 shows a massive spike in the use of mirror orders. This is a sophisticated legal maneuver where an attorney secures identical court orders in two different countries simultaneously. Step by step, the process involves filing a case in the U.S., obtaining a temporary ruling, and then immediately hiring local counsel in a second country to mirror that ruling in the local language and legal code. This ensures that if a spouse attempts to flee or move assets across borders, the legal net is already in place. The cost for this level of multi-jurisdictional synchronization is astronomical, often requiring a lead global counsel to manage a fleet of local attorneys in 3 or 4 different time zones. Another significant driver of the 2026 international market is the foreign trust piercing industry. Historically, offshore trusts in places like the Cook Islands or Nevis were considered bulletproof. However, the legal market has evolved. Attorneys now use international discovery requests and Hague evidence conventions to bypass bank secrecy laws. They are no longer looking for the money itself, they are looking for the control nexus. If a U.S. attorney can prove that Sophia is still effectively controlling the independent foreign trust from her laptop in Seattle, a U.S. judge can order her to repatriate those assets under threat of contempt. This has created a cat-and-mouse game where the attorneys who draft the trusts are constantly being outmaneuvered by the attorneys who specialize in breaking them. Data from the 2026 fiscal year suggests that international cases now represent nearly 15% of the total revenue for top-tier U.S. family law firms, up from just 5% a decade ago. This growth is driven by the global talentscape. As more people marry across borders and hold assets in decentralized protocols, the standard divorce is becoming a rare commodity in the high-end market. The international specialist is no longer a niche player. They are the new industry standard. But what happens when the legal battle goes beyond assets and children? What happens when the attorney market enters the realm of reputational warfare? In the global age, a divorce is not just a legal event, it is a PR crisis. In the 2026 market, we are seeing the integration of crisis management firms directly into the legal team. The attorney's job is no longer just to win in court, but to ensure that the international narrative of the divorce doesn't destroy the client's global brand or career. In this deep dive, we have seen how the legal market has weaponized international treaties and exploited jurisdictional gaps. We have moved from the local sheriff's office to the federal court and into the sovereign conference rooms of the world's elite. The U.S. divorce attorney is now a global strategist, navigating a planet where the law is often a matter of geography, and the price of escape is measured in 7-figure retainers. In the next part of this 10-part masterclass, we are going to explore the dark side of the digital divorce. We will examine the role of deepfakes as evidence and the rise of AI-generated infidelity. We will break down the digital forensic arms race, where attorneys use machine learning to detect synthetic content intended to frame a spouse in custody battles. We are moving from the physical world into the virtual courtroom, where the truth is no longer what you see, but what you can prove hasn't been fabricated by an algorithm. The 2026 evidence lockers are full of code, and the next battle is for the authenticity of the record. The authenticity of the record is the new frontline of the 2026 divorce attorney market. In an era where generative adversarial networks and high-fidelity diffusion models can create a photorealistic video of any human being in under 30 seconds, the traditional concept of video evidence has collapsed. This has triggered a digital forensic arms race that has fundamentally altered the billable structure of family law firms. Historically, an attorney would spend hours reviewing bank statements. Now they spend days authenticating pixels. This shift is not merely a technical hurdle. It is a structural transformation of the U.S. legal market, where the burden of proof has shifted from the content of the action to the integrity of the data. Imagine if you are James, a systems architect at a leading defense firm in Northern Virginia in 2026. James is in the midst of a contentious custody battle. His spouse, Emily, submits a video file to the court through her legal team. In the video, James appears to be physically aggressive and verbally abusive toward their children in a dimly lit living room. To the human eye, the video is indistinguishable from reality. The lighting matches the architecture of James's actual home. The voice has the exact timbre, cadence, and subtle breathing patterns that define James's speech. James knows this event never happened, but in the 2026 market, a simple denial is legally insufficient. In this landscape, the attorney market has developed a specific response: the synthetic content challenge. James's attorney does not just argue his innocence. They trigger a mandatory forensic audit. This is a multi-step process that involves hiring a specialized digital evidence authenticator. In the 2026 market, these experts have replaced the traditional private investigator as the most expensive line item in the discovery budget. The forensic team begins by examining the file's metadata, looking for inconsistencies in the timestamp or the device origin signature. However, sophisticated AI tools can now spoof metadata, so the analysis must go deeper into the physical properties of the media. The technical depth of this analysis is staggering and represents a massive expansion of billable labor. The forensic lab uses secondary AI models to detect what are known as generative artifacts. These are microscopic errors in the way light reflects off the cornea of the eyes or the way blood flow, undetectable to the human eye but measurable by software, causes minute changes in skin tone, a process known as RPPG or remote photoplethysmography. If the pulse detected in the video does not match the physiological variability of a real human being, the evidence is flagged as synthetic. The cost for a single forensic verification report in 2026 often exceeds $15,000. Historical trends show that the cost of defending one's reputation in a divorce has shifted from character witnesses to computational verification. This shift has also birthed a new subsector of the market: the immutable communication strategy. Divorce attorneys in 2026 are increasingly advising their clients to move all interactions, text, voice, and video, onto blockchain-verified communication platforms. These platforms utilize a decentralized ledger to create a permanent, tamper-proof record of every interaction. When a client sends a message, a cryptographic hash is generated and recorded on the ledger. If the opposing party attempts to present a modified version of that message in court, the attorney can simply compare the hash of the evidence with the hash on the ledger. This has created a new standard of proof where the record is considered authentic only if it has a verified chain of custody that is independent of the user's devices. The academic review of these 2026 case studies reveals a disturbing trend: the use of AI-generated infidelity as a leverage tool in settlement negotiations. Imagine if Emily, wanting a larger share of the marital estate in a fault-based jurisdiction, uses an AI voice cloning tool to create an audio recording of James confessing to an affair. Historically, voice recordings were powerful smoking guns. In the current market, they are treated with extreme skepticism, yet the psychological impact remains. Even if a recording is eventually proven to be a deepfake, the initial exposure can bias a judge or a mediator. This is the anchor effect, where the first piece of information presented, even if false, sets the emotional tone for the litigation. To counter this, the 2026 market has seen the rise of reputation insurance for high-net-worth individuals. These policies provide specialized legal and forensic funding, specifically to fight deepfake evidence in domestic relations cases. The insurers recognize that the potential outcome of a case lost due to fabricated evidence is so severe both in terms of asset loss and career damage, that there is a viable market for protecting against digital frame-ups. For the divorce attorney, these policies are a reliable source of revenue, as they provide a pre-approved budget for the high-tech litigation required to debunk synthetic media. Furthermore, the judicial system in 2026 is struggling to keep pace with the speed of these technological advancements. Many states have introduced mandatory AI literacy training for family law judges. These seminars, often taught by computer science professors and legal tech pioneers, explain the difference between a simple Photoshop job and a deep learning-based synthetic video. Despite this education, the legal standard for admitting evidence is in a state of flux. Some jurisdictions are considering a move toward a presumption of inauthenticity for all digital media that does not carry a verifiable cryptographic signature from the capture device. This has led to a massive increase in the billable hours required for pre-admissibility hearings. In these proceedings, the attorneys and their respective experts argue for days before a single piece of evidence is even shown to the judge. They debate the reliability of the detection software and the statistical probability of a false positive in the forensic report. Historical data from 2026 shows that these evidentiary battles can account for up to 40% of the total legal fees in a contested divorce involving high-tech assets or high-conflict personalities. As we analyze the impact on the client, the story of James and Emily illustrates a broader societal issue. The digital divorce is no longer just about splitting accounts. It is about defending the very concept of reality. The market for divorce attorneys has evolved into a market for truth management. If you cannot prove that the record of your life is authentic, you lose your leverage in the negotiation. This is why the 2026 attorney is as much a technologist as they are a lawyer. They must understand the nuances of neural networks and the mechanics of digital watermarking to protect their clients from the dark side of the algorithmic age. The historical evolution of the divorce market has now brought us to a point where the human element is being squeezed out by the computational element. The billable hour is now tied to the processing power of the forensic lab. As the cost of proving the truth becomes prohibitive for the average person, we are seeing a widening gap between those who can afford certified reality and those who are left to the mercy of unverified digital records. This technological warfare has also impacted the prenuptial market. In 2026, we are seeing a massive resurgence in the demand for premarital agreements, but with a new twist. Modern prenups now include digital conduct clauses that specifically outline the types of evidence that will be admissible and the penalties for attempting to introduce synthetic media. As we transition into the final segments of this masterclass, the stakes have never been higher. The divorce market is moving beyond the courtroom and into the boardroom of the family's future. We have seen how the elite escape, how the middle class is automated, and how the truth is contested. But there is one final piece of the puzzle: the total collapse of the traditional alimony model and the rise of the self-sovereign household. In the next part of this deep dive masterclass, we will explore the prenuptial renaissance and the end of lifetime spousal support. We will break down the new 2026 statutes that have effectively turned marriage into a term-limited corporate partnership. We will analyze the earn-out models for alimony and how attorneys are now drafting sunset clauses into every marriage license. The romantic ideal of until death do us part is being replaced by the pragmatic reality of until the contract expires. We are moving from the record to the contract. The shift from the record to the contract signifies a fundamental transition in how the United States legal market perceives the institution of marriage itself. In the year 2026, the divorce attorney is no longer merely a reactive litigator, but an architect of domestic infrastructure. The historical trend shows that we have moved past the era of the one-size-fits-all marriage license and into an era of high-precision, multi-layered domestic contracts. This is the prenuptial renaissance, a period where the legal industry has successfully rebranded premarital planning from a pessimistic insurance policy into a necessary component of modern financial literacy. Imagine if you are Marcus and Chloe, two professionals living in the Seattle tech corridor in 2026. Marcus is a lead developer for a decentralized finance platform, and Chloe is a senior consultant for a biotechnology firm. When they decide to marry, they do not simply sign a state-issued document. Instead, they hire a team of attorneys to draft what is essentially a joint venture agreement for their personal lives. This agreement doesn't just list assets. It outlines the operational protocols for their marriage. It includes clauses for capital contributions to the household, the intellectual property rights of side projects started during the marriage, and the specific methodology for valuing their labor should the partnership dissolve. This corporate-style approach to marriage has led to the rise of the sunset clause as a standard feature of 2026 matrimonial contracts. Historically, a sunset clause was used in legislation to ensure a law would expire unless renewed. In the modern divorce attorney market, this has been adapted to the marriage contract. A 2026 prenuptial agreement might include a provision stating that all terms regarding asset division and support automatically expire and must be renegotiated every 7 years. This creates a recurring market for legal services within the marriage itself. Attorneys are no longer just present at the beginning and the end. They are periodically engaged to perform a mid-marriage audit to update the contract to reflect current financial realities. One of the most complex and high-value areas of this new market is the earn-out model for alimony. Historically, alimony or spousal support was often based on a permanent or long-term obligation intended to maintain a spouse in the station of life they enjoyed during the marriage. However, by 2026, many states have moved toward a rehabilitative or transitional support model. The attorney market has responded by importing concepts from mergers and acquisitions. In an earn-out model, support is not a fixed monthly payment, but is tied to specific performance milestones. Step by step, the calculation of a 2026 earn-out looks like this. First, the attorney identifies the domestic contribution of the non-earning or lower-earning spouse. This is quantified using data from the Care Economy Index, which assigns a market value to domestic labor, child-rearing, and household management. Second, the attorney calculates the career damage or opportunity cost incurred by that spouse during the marriage. Finally, the support obligation is structured as a series of investments intended to bridge the gap between their current earning capacity and their potential capacity. If the recipient spouse completes a degree or reaches a certain income threshold, the support obligation may decrease or terminate. This shifts the focus from a lifetime entitlement to a targeted economic stimulus. The historical data from 2026 indicates that this model has significantly reduced the duration of support litigation. When the rules are formulaic and based on market data, rather than judicial discretion, the potential outcomes become more predictable. This predictability is exactly what the market demands. High-net-worth clients are willing to pay a premium for a contract that removes the uncertainty of a future court battle. Case studies of 2026 high-conflict divorces frequently show that parties with these sophisticated contracts spend 60% less on legal fees during the dissolution phase because the bulk of the work was completed and paid for during the contracting phase. However, this move toward marriage as a term-limited contract has profound implications for the legal market structure. We are seeing the emergence of the domestic general counsel. These are attorneys who work on a retainer basis for families, much like a corporate counsel works for a business. They manage the prenuptial agreements, the postnuptial updates, and the various trusts and holding companies that define the modern marital estate. This provides a steady, predictable revenue stream for law firms, contrasting with the feast or famine nature of traditional litigation practices. Furthermore, we must analyze the legislative pivot of 2026. Several U.S. states are currently debating the implementation of the renewable marriage license. This would effectively turn marriage into a 5-year or 10-year contract that requires a proactive filing to renew. If the parties do not renew, the marriage is automatically dissolved according to the terms of their pre-negotiated exit strategy. The attorney market for drafting these renewable contracts is projected to grow into a multi-billion-dollar sector over the next decade. The legal expertise required here is not just in family law, but in contract law, tax law, and future value modeling. Imagine if Marcus and Chloe opted for this renewable model. Their attorney would set a calendar alert for their 5-year renewal date. 6 months prior, the firm would initiate a review of their joint and separate assets. They would analyze whether the original terms of the agreement still align with the couple's current goals. If Marcus's startup has gone public, or if Chloe has inherited property, the contract is adjusted. This turns the law firm into a long-term strategic partner, rather than a crisis interventionist. The transition from the record to the contract also impacts the custody market. In 2026, we see the rise of the parenting plan algorithm. Attorneys are now drafting parenting plans that utilize smart contracts to manage scheduling and expenses. If a parent is late for a pickup, the system automatically triggers a pre-negotiated credit or debit in the child support account. If a parent wants to take a vacation that conflicts with the established schedule, the algorithm calculates a trade-off in future time. This reduces the need for constant attorney intervention in day-to-day disputes, but it requires an immense amount of high-level legal engineering at the outset to ensure the algorithm accounts for all contingencies. As we look at the historical trends, it is clear that the U.S. divorce attorney market has successfully commoditized the entire life cycle of a relationship. By framing marriage as an evolving corporate entity, the industry has created a framework where legal intervention is normalized, expected, and continuous. The romantic ideal of a lifelong unexamined union is being replaced by a pragmatic, data-driven partnership that is constantly being audited, updated, and recontracted. But as we reach the pinnacle of this contractual evolution, we must ask, what is the final destination for this market? We have seen the elite hide in private courts, the middle class automated by apps, and the truth contested by AI. We have seen the state maximize collections and the global elite hop borders. Now we see the very nature of the marriage bond being rewritten as a series of renewable financial terms. In the final part of this masterclass, we are going to look at the ultimate conclusion of this trajectory, the post-human legal market. In Part 10, we will explore the fully autonomous divorce, where AI attorneys represent AI entities, and the human element is removed entirely from the adjudication process. We will look at the social credit impact on divorce settlements, and how your digital reputation in 2026 has become the most valuable asset in the courtroom. We are moving from the contract to the algorithm. The market is about to go dark, and only the machines will know the true cost of goodbye. The algorithm is the final frontier of the U.S. divorce attorney market, representing a transition from human judgment to computational certainty. As we enter the final stage of this masterclass, we must analyze the rise of the post-human legal market, where the traditional courtroom is being replaced by a digital black box. In the year 2026, we are witnessing the emergence of autonomous adjudication, a system where legal disputes are no longer argued before a jury of peers, but are processed through a series of predictive models. This is not a sudden shift, but the culmination of a decade-long historical trend toward total quantification of domestic life. Imagine if you are Kevin, a mid-level analyst in Chicago, and your spouse, Maya, a developer of virtual environments. In 2026, your divorce does not begin with a meeting in a mahogany-lined office. It begins with the activation of two competing AI legal agents. These agents are not just chatbots. They are sophisticated neural networks trained on every family law case filed in the state of Illinois over the last 50 years. Historically, an attorney would spend weeks researching precedents to find a favorable angle. In the 2026 market, Kevin's AI agent performs this task in 400 milliseconds, identifying the historical trends that favor his specific financial profile. This leads us to the concept of algorithmic advocacy. When Kevin and Maya's agents engage, they are not looking for a compromise in the human sense. They are seeking a Nash equilibrium, a mathematical state where neither party can improve their outcome without a corresponding loss for the other. This process is known as high-frequency negotiation. The two AI models trade thousands of settlement variations per second, adjusting for tax implications, future inflation, and even the predicted career trajectory of both parties. The market for the human divorce attorney has shifted here from being a negotiator to being a prompt strategist, responsible for setting the initial parameters and ethical guardrails that the AI must follow. The valuation of assets in 2026 has also moved into a post-human phase. We are no longer just talking about houses, cars, and 401k plans. The modern divorce attorney must now account for attention assets and digital reputation capital. For instance, if Maya has a significant following in a virtual social layer, that presence has a measurable market value based on its ability to generate future revenue through data harvesting and digital sponsorships. In a 2026 case study, we see the emergence of reputation audits, where an attorney hires a data scientist to calculate the social trust index of each spouse. This index is a critical component of the data-driven moral compass used in modern custody battles. Historically, character was proven through testimony. In 2026, character is a data point. The court's algorithm analyzes Kevin's digital footprint, his history of contract compliance, his online sentiment, and even the biological data from his wearable devices. If Kevin's predictive volatility score is higher than Maya's, the algorithm may suggest a custody arrangement that favors the parent with the most stable data profile. This represents a shift from the best interests of the child standard to the algorithmic risk mitigation standard. Step by step, the 2026 divorce process has become a sequence of smart contract triggers. Once the AI agents reach a settlement, the agreement is encoded directly onto a blockchain. This is the self-executing divorce decree. In the historical market, if Kevin failed to pay child support, Maya would have to pay an attorney to file a motion for contempt. In the 2026 landscape, the smart contract simply monitors Kevin's digital wallet. If the payment is not made by the designated timestamp, the contract automatically triggers a transfer of funds or places a temporary lock on Kevin's liquid assets. The market for enforcement litigation is being systematically dismantled by the efficiency of decentralized finance. However, the academic review of this post-human market reveals a significant ethical singularity. As the law becomes more complex, it reaches a point where it can only be interpreted by the machines that wrote it. This is the black box problem. If the algorithm decides that Maya should receive 60% of the marital estate based on a complex web of predictive data, can a human judge truly explain the reasoning behind that decision? In 2026, we are seeing the rise of algorithmic auditors, a new breed of legal professional whose job is to verify that the AI's decision-making process is free from coded bias. This has created a secondary market that is almost as lucrative as the divorce litigation itself. Another major shift is the partitioning of personal AI models. Imagine if Kevin and Maya spent 10 years training a domestic AI to manage their household, schedule their lives, and curate their digital experiences. This AI is a repository of their collective memories and preferences. In 2026, the divorce attorney must handle the partitioning of weights and biases. How do you split a neural network? The legal market has developed model splitting protocols, where the AI is effectively cloned, and each party receives a version of the model that has been sanitized of the other person's private data. The cost of this digital surgery is one of the highest growing expenses in the 2026 family law budget. As we conclude this 10-part deep dive masterclass, we must look at the final market synthesis. The U.S. divorce attorney market has traveled an incredible path. It began in the clandestine divorce mills of the early 20th century, moved through the no-fault revolution of the 1970s, expanded into the forensic accounting era of the 1990s, and has now arrived at the algorithmic singularity of 2026. Each era was defined by a specific type of capital, first social, then financial, and finally digital. The modern attorney is no longer just a legal advisor. They are a data architect, a crisis manager, and a technological arbitrator. They navigate a world where a divorce is a high-speed data transfer, and where the potential outcomes are determined by the quality of one's code, as much as the strength of one's character. The market is not disappearing, it is merely becoming invisible. As litigation moves into private servers and settlements are reached by machine learning models, the public's visibility into the mechanics of divorce is fading. We have explored the shadow judiciary, the international gray market, and the deepfake evidence lockers. We have seen how the Title 4D agency turns support into state revenue, and how hedge funds bet on the outcomes of family disputes. This is the reality of the U.S. divorce market in 2026. A $50 billion engine that thrives on the most intimate transitions of the human experience. Whether through an app, a private judge, or an autonomous agent, the industry has ensured its place as a permanent fixture of the American economy. But even as the machines take over the mechanics, a fundamental question remains. Can a line of code truly capture the nuance of a human?